fault. So, all right. All right. Good morning, everybody. Again, I am referee Brian Nicholas with Macomb County Family Court. And could counsels for the parties please state their appearances for the record?
Good morning, Robert Sogi on behalf of the plaintiff and moving party, Amber Bursick, now Amber Muscat.
Good morning, Your Honor. My name is Aaron Ingber. I'm here with Zelenko Bursick.
All right. And ma'am, your name for the record?
I'm Amber Muscat.
All right. And sir, could you please state your name for the record?
Zelenko Bursick.
All right. And guys, I want to thank everybody for appearing via Zoom today. Please realize this is a legal proceeding, just as if you guys were all present in the courtroom. Sir, any questions for myself or your attorney regarding that this is a legal proceeding?
Sure.
All right, ma'am, any questions for myself or Mr. Sogi regarding that this is a legal proceeding today? All right, if no questions, guys, we're here today on plaintiff's motion regarding determination school for the minor child and extracurricular activities. Counsel, if you would like to proceed.
Yeah, thank you. I know you read the motion, so I want to hit some key points. There's a couple of factual disputes that have arisen after receiving defendant's response. One is where he says that he attends conferences. He says he attends many conferences. I can tell you that I have confirmation from Great Lakes that he did not attend any conferences at that school. He rarely, if ever, attended conferences at L'Anse Creuse, and they would have been in person prior to COVID. He just didn't go. I don't know why he's claiming that he went, but he just doesn't. The other factual dispute that he raises is he claims that the child isn't doing well in school because plaintiff isn't doing her job. And he represents that there were 20 missing assignments when she attended L'Anse Creuse and 12 missing assignments when she attended Great Lakes. Again, I have confirmation from Great Lakes that she finished the year with 0 missing assignments. There's an app that the parents can use for Great Lakes where they can follow whether or not the child has any missing assignments. I went through the app day by day and was able to determine that this child did not miss any assignments. So I don't know why defendants coming to court raising these factual issues that are just clearly wrong. The next one is he claims that she's engaged in numerous extracurricular activities. He just says whatever he wants. It doesn't matter whether there's any truthfulness to it or not. She's involved in horseback riding, where you're not involved with other kids. It's you and the horse. So that's not going to increase her socialization. And she's involved in the softball, which we had to come to court and ask you to grant, and you did. And now that's up for hearing again as well today. But for that, the child has no friends, no socialization, and her development is just kind of stymied in that regard. The other thing is he says, well, she gets good grades. Well, defendant is confusing grades with her learning. And I attached to my motion her test results from Great Lakes that says she's doing math at a 3rd grade level. I think it was 3rd percentile. It means 99 out of 100 people are doing better than her. It's the same thing with reading. Her reading's at a 4th grade. She's going into 8th grade. So I know she's an IEP student, but this school where right now what she's doing is it's passing time. It's a waste of time. He's not involved in the process. He doesn't go to the appointments. He doesn't go to the parent-teacher conferences. This all falls on plaintiff's lap. Now, the parties initially started out with this child in St. Germain. They realized the significance and value of a private education, and they split that expense. This child, when we say she was pulled from L'Anse Creuse because of behavioral issues, I want the court to know she had 1 detention for being late to gym class. That's it. 1 detention for being late to gym class. She didn't get in any other trouble, and she turned in all of her assignments. And her grades were not bad considering her IEP status. Now, what happened was this plaintiff saw a video of her on her phone vaping. That's what happened. Vaping. That's what this child did. This child was not a behavioral problem. This took care of it. What plaintiff was most concerned about is the kids that she was hanging around with at L'Anse Creuse. That's what this was all about, to get her out and away from these kids that she was hanging around. That's been accomplished. So this Lutheran North thing, where they do have an IEP program, they are more than happy to accommodate this child. Solves that problem. Plaintiff is willing to incur the significant expense. It's going to be $8,500 a year to send her there. Plaintiff's willing to do it to appease defendant to get her away from the bad kids. So this girl is not a bad kid. And this, one slip up with the vaping and defendant wants to shelter her from the world for the rest of her life. We can't do that. The other issue that's brought up is the softball. Had to come to court to get it. We've had to come to court to do anything with this child. Defendant just wants her sheltered. Plaintiff was mistaken. She thought that for this age bracket, it started in April. It didn't. It just started. So the order was basically for naught. And now defendant, we accommodated him. The point was, I don't want to have to drive her to games. I don't want to have to put myself out to go. So you only ordered one season. Unfortunately, we were wrong about the dates. That season just started. So now, again, he doesn't want this child to participate in softball. And the end result is, if we don't make a change, she's not going to, it's going to be a 2-week season. He says in his motion that plaintiff switched leagues. We didn't switch leagues. It was just an honest mistake. The last thing is, he's extremely critical in his response about us having to file this motion and that we're trying to take custody. The fact that, and we didn't discuss it with him, the fact of the matter is, she asked very nicely on the app close. She laid out in detail all the reasons she thought would be beneficial for this child to go to L'Anse Creuse North. And he just said no. And he came back with a long list of why not. Well, that's it. No means no. You have to go to court at this point. He's arguing that she's unilaterally trying to do it. She's not. She asked. He said no. Here we are. This is the natural result of that. So, I feel bad for her. Every time she wants to do something with this child, the defendant's like, no softball, no school. It just isn't working. So I'm asking that the court refer it. You can make the decision today because it's a no-brainer. She's performing at a 3rd grade level and she's going in 8th grade. Public school, or at least this Lutheran North, where they have been more than accommodating, seems an appropriate choice.
All right. And guys, let me ask a couple questions before the response, just to clarify. So you guys, your daughter's 13, is that correct?
She just turned 14.
Okay, she just turned 14. And the current schedule's the 16th circuit with alternate weeks in the summer. So dad has every other weekend during the school year and alternate weeks in the summer.
Yeah, yes.
All right. And so as a starting point, just as an aside, guys, if she's with mom during the school week and mom's saying, I don't want to do virtual schooling, does that mean defendant wants to do virtual schooling during the week? Because it's pretty difficult to order a party to do virtual school if they're saying they don't want to do it anymore.
He would love to do that. He believes that if she was with him during the schooling, then she would be doing much better.
Okay. Well, let me ask this. So how does IEPs work with at-home schooling? So individual education plans are, you guys meet in public school with a team of experts that addresses any deficiencies or catch up or whatever your child needs to deal with whatever the reasons they qualify for the IEP. How does either party have the ability to do individual education plans or any kind of specialized homeschooling? What qualifies the party, and is even that possible to do as a virtual school? Tell me how that works, guys. Either party. Go ahead, ma'am.
So through the virtual learning, she has these small groups that she can meet with, but they are optional. So that's how, and she can use a calculator, but I do have an email. I did not bring it with me, but when she was doing in-person in L'Anse Creuse, I had an email from her math teacher that there was like 3 kids in class. She was doing well in the in-person. She's just not motivated at home, and she's unhappy she's just not motivated to go to the extracurricular classes.
Okay. And let me ask this, does your daughter have any kind of social issues or mental health diagnosis or anything that she's being treated for with a counselor that would make somehow in-person learning, the socialization from that detrimental or
Well,
adverse to any
I
kind
can
of?
answer that.
Okay.
We did have to
Okay,
come,
go
we
ahead.
did have to file a motion to get the child in counseling, and she
No,
is in counseling currently, but she
You did
just
not have to
started.
file a motion. The second
Yes, we did.
Okay.
well, you filed it, but you never saw concurrence. The
Okay,
second I saw
okay,
that
so
motion,
guys,
I gave you a
that's not
call
true.
and told you
Okay.
that he's in agreement.
Guys, stop. Guys, stop. It's neither near here nor there, this counseling issue. If it's being brought up to say the parties disagree, that's another issue. That they don't agree on anything. My question right now is does your daughter have any adverse social issues or diagnosis that makes it detrimental for her to be socialized? Because I'm going to be honest to both parties, and I haven't heard the response yet. But guys, I've done this a long time, 20 some years. And generally it's the court's preference to have socialization and those issues. And that tends to be my preference, unless there's some reason that's detrimental to a child. That, it's not easy, one, to homeschool, two, to keep a child motivated, to have them have that socialization. And also you have a child that qualifies for an IEP. And I'm sure both parties, as lay people, unless they have educational backgrounds, I would think IEPs are much more difficult virtually at home as a parent than having a team at a school, an IEP team of which you meet with, addressing those needs that way. So we'll go back to how I started my big speech here. Does she have any diagnosis that makes in-person detrimental or adverse to that kind of learning environment?
She does not have a diagnosis. She just started therapy, but she has developed social anxiety from the past year from not being in school. She was never like that before, but now she's afraid to go to the bathroom by herself or like out in public. She does fine with softball. It's her team. She's fine with that type of situation. But if we're in public at a restaurant, she doesn't want to go to the bathroom by herself, or she's just by me the whole time, which is fine. But this is because of homeschool, not because that's how she has always been.
And do you guys know the difference between class size between L'Anse Creuse and Lutheran? Is it Lutheran North? Is that where?
A 17-to-1 ratio. And then L'Anse.
So a lot, yeah, probably a lot higher at L'Anse Creuse, I'm betting. Yeah. All right. And so counsel, I'm going to let you respond, your response to their motion and any questions I may have asked of the parties.
Yes. So what got the child to be in this homeschooling was a decision of both of the parties. They came to an agreement together. They did it based on behavioral issues. There was vaping. There was serious concerns. Additionally, when the child was going to in-person schooling, her grades were horrible. She was at a very low percentile in math and English and everything back then. They've been down this road before. There was actual reasons why they together made a decision. We talk about all their disagreements, all their arguments going on. This was something that they decided together to do because they thought it was going to be better for the child. You look at her grades, the grades that they attached to their motion, and it shows her grades have improved from homeschooling. She was getting in with the wrong crowd. It was a bad situation. She has expressed her desire to my client to, that she, or not desire, but she explained that she has anxiety about going to in-person school. She was getting in with the wrong crowd and things have gotten a little bit better. Yes. Is she doing perfect in school now? No, but that's not necessarily the program. What the problem is the lack of monitoring on plaintiff's side. He has the availability. He will make himself available to help with the homeschooling or to be the primary person involved.
What does he do for work?
Mr. Barisic?
I'm a truck driver, sir, local.
So how could you be home during the day and helping your daughter with school if you're driving a truck?
My wife is home every day, and it will be a parent at the house. Let's say last 2 semesters, Anna was all by herself at the house, or with some old lady, whatever, that didn't pay attention to her. I don't know what's going on because I don't know. I never know the truth, but I know for last 2 semesters she was not oversight. There's no oversight. There's no consistency. She's a very strong-willed girl, and she just needs constant oversight, and she'll do 100% better. But when you let her loose, she's gonna run loose. And
And they
I just
had a-
don't want that.
Well, let
There's
me ask this
actually a
based on,
conversation, just one thing real quick. There was actually a conversation between the parties about 6 months ago. The child came to my client and said that she may want to go back to in-person school. They discussed this and said, hey, if you get your grades up, we'll let you back in there. And it was a decision of both parties to put the power back in her, see if she can get her grades up. And if she does, then they would reward her by getting her back in. So they've had this conversation. It's just a matter of when and how,
well, counsel, didn't you, with all due respect, didn't you say her grades are improved and they made a deal if her grades improve, she go back to virtual? So then why,
if she gets the A's and B's,
hasn't she met the deal?
if she gets her A's to A's and B's.
Okay. And what about, well, let's talk about baseball. What about softball? What's the position regarding that?
The same position he had before. He doesn't want to stop her from being in softball. However, she chose a league that is far away from where he lives. If she wants to pick a league that's closer to him, he'll be okay with it. But she unilaterally chose a softball league that's far away, and that's why this was addressed before, and we came up with the resolution that we had.
And what was the resolution? Was it a league in between them or what? Ma'am, you'll get a second. Just wait.
Well, the resolution was that she could have the child enrolled in one season, but not, when it's week on, week off.
I mean, you guys do realize that just to be blunt, I mean, if you're arguing for homeschooling, but then you don't want to do a socialization activity such as softball, it tends to be counter to each other. I mean, at some point, if there's homeschooling, the court highly encourages socialization, and that's generally through team sports or some other kind of extracurricular. And it would seem counter to argue for homeschooling, but then not to participate in a team sport. Just as an aside, guys, just to making a point. You guys are welcome to respond to that.
Well, that's fine and all. He's had no say whatsoever in where the league's going to be. If it's going to be somewhere closer, so he doesn't have to drive, a half hour every time he's going to take the child to softball, that would make it a lot easier for him.
It's the same league that she started in years ago, St. Clair Shores. It's not by us either.
So, Mr. Barisic, tell me your feelings about the softball. Is it something your daughter loves and wants to play, or she doesn't really like it? Or you don't? What's the point?
She loves it. She's all about it, and I'm all about it. Any sport, I played sport all my life, but we never.
Okay.
She just picked. Last year she picked Harrison Township. This year she picked St. Clair. And I'm just supposed to okay, let me do it.
Okay. So, as a starting point, you just told me your daughter loves softball. So I would think you guys would want to pick a league she can participate in. What league do you want her in?
Closer to my house.
Where do you want her to play?
At least
What city is each of you in?
I'm in Dearborn Heights and she's in Harrison Township.
Okay. So where do you want her to play? So if you don't want her in St. Clair Shores, what's your district that you want her in? You should have a counter league that you want to. Ma'am, you'll get a second. Ma'am, you don't have to put your hand up. So obviously, if you want her to do another league and she loves baseball, I would think you'd come in today and say, well, instead of St. Clair, this is the league. This is when it starts, and this is where I want her to play. Do you have a counter league you want to propose?
I don't have any. I did not look into any, but I'm open to anything that we can settle this.
Well, you're here saying you don't want her to participate in softball, but then you say she loves it. You loved it. You played it. She loved it. I would think you would say, if I don't want to drive her to St. Clair Shores, you'd have another league.
No, sir.
Last time we were here, we presented the schedule, and all of the games and practices were on my client's time. It was going to be minimal involvement for the defendant, maybe once a week. And my client can tell you, what the schedule is this time.
They have week on, week off during the summer, right?
Yeah.
Yes.
Okay. So what's the schedule, ma'am? What's the softball schedule? For practices and stuff.
Let me pull. Okay, so practices are on Sunday and Tuesday, and the games start from June 21st to July 28th, and there's 2 games a week. But I'm not even picky. If he can just take her once a week to a game, that's totally fine. You gave me the option to take her, if he could not take her, to take her to her game. And that's what happened with her very, very first game. It was on his schedule. He said that he was far away, couldn't take her. I ended up going to his house to get her, and he's there. He was there when I dropped or picked her up and when I dropped her off at home, when it was her very first game. And last year, this wasn't even an issue that it was in St. Clair Shores because he never participated. He never took her to any of her
Okay.
games, and he never even
Well,
went to any of her games. So
let me ask this. If you're willing to do the transportation for him, would you be willing to do a league closer to him?
if that's what if you'll be willing to take her, but I mean, she likes St. Clair Shores because that's where her friends are. Her friends joined, like from last year, she has some of the same people on the same league.
So is she good? She loves softball. She's good at it. She likes it.
I mean, she's not great, but we're getting better. You know,
Okay.
I'm hoping that if I
All
can get her into Lutheran North, she can do softball there as well.
All right. All right. All right. Council, anything else? I know I keep interjecting, Mr. Ingbar. If anything else, I'll promise to stop interrupting you here. If you have further more you want to say.
I mean, that's about it. At the end of the day, like, he wants what's best for his child as well, you know? And that's all he really wants. They have a different opinion on what's best. They came to an agreement before, and we're just asking for them to honor the agreement that they've already made.
Okay. So guys, I think, and ma'am, you wanted to add something?
I'm just saying, we had an agreement to put Anna in homeschool for 8th grade. There was no conversation had on keeping her homeschooled for the rest of her life. This was just for 8th grade. There was nothing communicated about high school or anything like that. So in my mind, I thought it was just a temporary thing to pull her away, to get her readjusted, to get her away from those kids and make better decisions. You know?
Yeah, but 4 or 5 months ago, when we talked about it, you agree, and you told your kid, I agree with your dad, when her dad told her, if you get all A's and B's,
I never
Would you
agreed
consider-
to that. See, Anna's
Guys,
never been a straight A
stop,
student.
guys, stop.
okay.
Do not yell at each other and argue. So, Mr. Barisick, let me ask this.
Yes.
So, to address the Lance Cruz issue, she's saying she will bind herself to pay the tuition for Lutheran North, which is going to cut the classroom teacher to student ratio in half. Parochial schools tend to, I hate to I don't want to generalize here, I'll get in trouble, but maybe discipline may be a little more aggressive there based on the smaller teacher to student ratio. She's going to pay the $8,500, which is a pretty big chunk of change for her to pay, and say you don't have to pay any. You don't see any beneficial to a smaller private school with her paying the $8,500 a year tuition.
Because we tried private school, and then we tried public, and then we tried virtual, and then due to COVID, and then we decided to stay at home this last year. And this last year gave me the best results. No school anxiety, overall much better grades, and have a pressure to do things with the wrong crowd. So I saw my kid this year actually much better than a private school that we paid for together in the past or public school. So
Let me ask this:
now,
do you each have other children? Have siblings of your daughter? How
Yes.
many do you have, sir? How many other children?
2.
And ma'am, how about you?
I have 3.
And where do your other children go to school, guys?
Public school.
So,
Mine
ma'am, your
is
other
a
two go to
1-year-old
public?
and a 3-year-old
Okay,
and
go ahead.
1-year-old. They don't go to school.
Okay, so yours are young. Do you guys practice the Lutheran faith, or is that an issue? The parochial Lutheran school, is that an
We
issue
go
for either
to
one
a
of you?
non-denominational church. We go to Kensington and Heritage.
Okay. So guys, this is why I keep talking so much during a motion hearing. I usually don't have, I'm trying to identify the issues that you're going to have, that the court's going to identify and probably focus on if you guys go to an evidentiary hearing, which means you're going to have to pay your attorneys to represent you. School is an issue, guys. You have a right to litigate school. If you guys haven't, I'm going to be blunt. I tend to favor in person for socialization issues unless there's a real reason not to, but that's not the beginning and end all. There's 12 best interest factors. So I don't want you to think, but you guys, obviously, I'm not going to lie. I think there's a lot of arguments while in person is better, especially when, you know, you're asking one of the parents to do all the homeschooling and you guys have an IEP. However, you have a right to a hearing, guys. I'll send it to a hearing. The only way to avoid this hearing is you guys agree to something now and not, or after I refer this. Otherwise, you're going to have to pair your attorneys to prepare for an evidentiary hearing on the benefits of homeschooling versus in-person and potential parochial. It's a pretty nice offer for someone to offer to pay the $8,500 tuition. And just so you know, I'm going to be blunt to ma'am, to you, you're not going to, if you offer that and it gets ordered by consent, you're not going to get out of it. I'm not going to play the
Totally
game.
fine. Next
To
4
be
years.
quite, I'm going to be blunt, and this is not to be disrespectful. I'm not going to play the game where you get her in, you get your daughter into
100%.
parochial school potentially
I
if he
want nothing
agrees.
from him.
But listen, I want him to hear this and you to hear this. I don't want to play the game that he agrees potentially, and I don't know if he's going to. I'm just making a point. If he agrees, and then a year from now you say, I can't afford it, I want him to chip into the school. I've had a change of income, my family has, I want him to chip in. It is not going to probably be successful. The court is going to highly scrutinize that. Probably not going to happen. So you're going to offer to pay $8,500 tuition as an incentive for him to agree. You're going to pay the tuition.
Okay.
And if you later say, I want to go back to public, that's going to be a problem too. Because I'm going to say this was all based on arguments on smaller class size, you paying, you got him to agree, you're going to be stuck with that. And it's going to be hard to get out of it. Does that make sense? Unless something huge happens. Go ahead.
Okay, I do also want to point out that in homeschool, she has 999 tries to retake a test or a quiz. And I have that in Mr. Soggy's office too. So obviously she could get better grades if she could retake a test over and over and over.
I got you. So Mr. Barasek, having listened to this, any questions for me or attorneys, or does it change your position at all based on this dialogue or not really? There's no wrong answer, by the way. I'm not going to get upset about whatever your answer is.
Honestly, I don't want to shelter like I'm accused of my kid. I'm willing to work with her if she wants to try this out. But if let's say this first year, if her grades are worse than they are right now, can I have a chance of going back to the homeschool?
So let me make this point, and your counsel's welcome to interject.
Okay.
Once an order is set, it's the person who wants to change it, who has the obligation, the burden to prove that it should be changed. So if you agree to go to Lutheran North, it's going to have to be some pretty compelling reasons to get the court to go back to virtual. I mean, you'd have to have some pretty progressed grade changes or something really not going well. I'm not going to lie, probably not the easiest thing to happen because you're going to have and Mr. Ingber, go ahead if you want to talk to your client.
What if by an agreement, if the grades aren't at a certain level, then they'd automatically agree to the following year that she go back to a homeschool. So that might be some sort of compromise.
I'll be honest, and I appreciate any proposals, but I'm going to be honest. In my view, that's more of a springing change of circumstances that is a finding of the court based on the best interest factors. And I'm not whether it's custody, parenting time, or school, I'm not a big fan of springing. I would define it as a springing change of circumstances and a finding that has to be made by the court. You guys are welcome to disagree with me or comment on that. I don't know. Any thoughts?
No, there's a lot more to it than her grades. Grades are one thing. She needs to be socially adapted.
Okay, so let me put this out there. So if Mr. Barasek, you want to decide to do an order today to let her go to Lutheran North, that's fine. If not, I can set this for hearing. You guys continue to talk to your attorneys, having taken into consideration what I've said, whether they agree, don't agree, they'll tell you their thoughts about the points I've made, and you guys can do a consent order, and then just call the court and say we cancel the evidentiary. Or you guys resolve it today, go ahead.
I'm willing to take a chance and let her go. I'm willing to take a chance and let her go and agree.
Okay.
Are you sure? And Mr. Ingber, you feel comfortable with your client saying that? I know everyone's on the spot and I'm kind of throwing it out there at everybody here.
I feel comfortable. Whatever, they can agree to is what it should be.
Okay, so Mr. Barasek, you know, if we agree, your daughter's gonna go to Lutheran North, she's gonna be liable for or I shouldn't say liable, she's gonna pay the tuition. It's a done deal. You can't object. Are you feeling okay, or do you want to talk to Mr. Ingbar, or you're okay
Yes, sir,
with that?
100%. I'm okay with it, 100%.
All right. And so what I'm going to do is for softball, if you can find a league closer, she can participate. Otherwise, St. Clair Shores, guys. If he's going to give in on the school,
Can
I don't
I-
want to.
Can I talk to my,
Go ahead.
Brian, can I mute and just duck my head in my client? She's right next door and
Yeah.
see what she wants.
Yeah, go ahead. And Mr. Ingbar, do you want to talk to your client at all, or
I might as well have a quick minute with him.
All right. So, he's on the phone. I don't know if, I'm going to open a breakup room really quick. So Mr. Barasek, you're going to have to accept it. If it doesn't go, I'll just close it down. I don't know if it's going to be hard on the phone. But let me just do that real quick. So I'm going to create a breakout room for you to privately talk to your attorney to make sure you don't have any questions and you're comfortable with your decision for
Okay.
Lutheran North. And then you can talk about the softball too. But all right. So I'm going to open up the breakout room. You have to accept it or it won't let you go. Should be getting that invite right now. All right. So we're still on the record. Mr. Barasek and his attorney are in a breakout room, and plaintiff is muted and currently talking to her counsel regarding this court's dialogue. All right.
All right. It's good to have them right here in the office.
All
How
right,
you
and just so
doing?
you know, Mr. Suki, they're in a breakout room briefly here. They wanted a brief breakout room. If you guys need to talk further, you're welcome to do so. I've just given them a couple minutes for Mr. Ingbar to make sure his client's fully comfortable with the consent.
Yep.
And any feeling about the softball, I'll repeat it to them when they come back. I'm not going to have an expert, so I'll tell them.
The season only goes till July 28th. It's already the 10th. That's, we got 18 days to deal with for her to, I think. So it's kind of a no big deal. Right, Amber?
All right, so I'll talk to him about it. I'm going to, obviously, guys, I don't have experts, so I'm going to repeat this brief dialogue.
I got you.
Them when they come back.
Yep.
And I'll just indicate when they come back, you made a point that there's only 18 days left. She's willing to do, ma'am, you're willing to do the transportation if it's St. Clair Shores, if he's unable to.
Yeah,
It's a lot of driving.
I was totally fine with
Okay.
that. When we made this agreement for our last motion, if I have to go pick her up because he's working and whatnot, I have no
Okay.
problem to do
All
that.
right, so they're coming back. So let me close this. And I'll just close it. So he might not know how to come back. I'll close it. And counsel, just so you know, repeat any dialogue we had. They're indicating there's 18 days left of the St. Clair Shores softball season. She'd be willing to do all transportation if Mr. Barasek would consider that. Are you back? And can you hear us, Mr. Barasek? Are you back?
If he
Yes, sir.
can't take her, I don't want him to try to fake me out and say I can't go and then have him be home
Okay.
like it was the
Okay,
first.
so stop. So Mr. Barasek, just so you know, I repeat anything that anyone said when you guys are in the breakout room, and the point was said when you guys are in the breakout room that there's 18 days left to the St. Clair Shores softball season, and Ms. Barasek would be willing to do transportation if you were unable to, if you were to agree, to the last 18 days of the season in St. Clair Shores. And I know that that's just something they brought up while you guys were in the breakout room. And in council, any thoughts about, you guys chatted in the breakout room? Are you guys still comfortable with Lutheran North?
Oh, yeah, he's comfortable with that. As far as the softball goes, I obviously didn't talk to him about finishing up this
Right.
season, but he will be looking for a league that's closer to him, and probably Dearborn Heights for a future season.
Okay. So Mr. Barasek, would you be cool with the 18 days in St. Clair for this year and indicate that that's for this year only, and you guys are to agree to a different league after this summer?
Yes, sir.
Okay. All right. So, and guys, if you guys are in agreement, I'm going to put one per agreement of the parties. The party's daughter shall attend Lutheran North, and plaintiff shall be responsible for 100% of the tuition. And then two, for the remainder of the summer softball season through July, and that's only through July 28th.
Yes.
To July 28th, 2023.
Yes.
The party's daughters shall participate in St. Clair Shores League.
And I only have to take her if he's working, not if he's home like he was the last time.
Well, you're asking him to agree. So if plaintiff is unable to, or defendant is unable to provide transportation and will not be attending the game, he shall contact plaintiff, who should be allowed to provide transportation. Does that make Mr. Barasek? So she doesn't want to come pick her up and then have you at the game, and you could have done the transportation. Is that okay?
No, I just don't want him
You're gonna
sitting at home, is what I'm saying. That's what happened the last time. He said, he made it
I know,
sound like
but-
he was working and he wasn't. He was at home.
Okay. Well, guys. Well, ma'am, let me make a point. He just agreed to Lutheran North without requiring a hearing and all that time and energy. So I take your wins where you can find them, and not debate the next 18 days. Does that make sense? So if he says he can't do it, you're entitled to do it. And for the remainder of the season, I'm going to put 3 for softball after the summer season. Parties shall mutually agree to a league. If unable to agree, either may file a motion with the court. So I'm going to plan on you guys agreeing. If not, you'll come back and pay to come back.
Amber,
Ma'am,
let it go, Amber. I'll talk to you about it.
Can I keep her in St. Clair Shores and then just do part-time if he doesn't want, like next year, if he doesn't want to participate in it, because that's where her friends are?
No. No,
What
I'm not gonna
about
make a
through
ruling on that.
Lutheran North if she decides to do softball through there?
Yeah, guys, guess what? You guys are parents. You guys need to talk to each other. If unable to talk, at some point, I'm going to send you guys to a therapist for you guys to work on the ability to communicate on the behalf of your child. This is for both of you. That you guys need to talk, about reasonable resolutions. Okay, so I'm not going to order St. Clair League after this summer. We talked about this summer. You said closer to him. Now we're going back on that. So talk as parents and talk. Hey guys, guess what? She's got to go to Lutheran. She hasn't even started. So go to Lutheran North, see if she has new friends, see if she wants to participate in that league. And as parents, talk to her and say, hey, does Lutheran North have a team? You have now friends there. Do you guys want to participate in Lutheran North? And you as parents decide where she goes. If not, come back to court. I'm not making a ruling on it now. She hasn't even gone to Lutheran North and established her social circle there. Okay? If not, you guys can object, but I'm going to talk to Mr. Sogi, ma'am. That's what I'll say. If he wants to object, you can object, but talk to Mr.
Worst case
Sogi.
scenario is you got to come hire me again. And I know you're getting tired of it. I get it.
So guys, all right. So guys, I got to get going here. So is everybody, so guys, if you consent, you waive the right to object. You make this a final order today. Obviously, you're not here to sign the order. If you tell me to sign this order on your behalf during a recorded hearing, it has the same effect as you personally signing it. When you get an order where you see your signature box, you will see a / symbol, the letter S, a / symbol, and your name printed. That represents a virtual signature and tells anyone in the future, including yourselves, that you directed me during a virtual hearing to sign it on your behalf. Again, the same effect as you personally signing it as if it has your personal signature. Ms. Barasek, are you directing me to sign an order on your behalf, consenting that your daughter goes to Lutheran North, that you are responsible for 100% of the tuition? She'll finish off this softball league through July in St. Clair Shores, and you guys have to mutually agree for any league thereafter.
Yes, Your Honor.
All right. You understand you're waiving the right to object?
Yes, Your Honor.
Do you feel that you've been pressured or coerced in any way, including by myself, to have to agree to this agreement against your will?
No, Your Honor.
You're doing it freely and voluntarily?
Yes.
Any questions for Mr. Sogi, your attorney, regarding this agreement?
I'm done talking for today.
Okay. All right. And, ma'am, you're directing me to sign this order on your behalf.
Yes, please.
Mr. Sogi, do I have your permission to sign the order on your behalf?
Yes.
All right, Mr. Barasek, are you directing me to sign an order by which your daughter will attend Lutheran North? And plaintiff will be responsible for 100% of the cost, and your daughter will finish off softball through July, the end of this month in St. Clair Shores, and you guys have to agree to any season hereafter.
Yes, sir.
And sir, do you feel that you've been pressured or coerced in any way, including by myself, to have to sign this order against your will?
No, sir.
You're doing it freely and voluntarily,
Correct.
and you understand you're waiving the right to object and for further hearing on the school issue.
Yes, sir.
All right. Any questions for your attorney, Mr. Ingbar, regarding this agreement, sir?
No, sir.
All right. And Mr. Ingbar, do you have your permission to sign your signature on this order as well?
Yes.
All right. Does council have anything they want to add before I conclude the hearing today?
Yeah, thanks for helping us get this done. I know it took a little time. Appreciate it.
Okay. All right. So guys, based on the testimony, all right. And guys, based on the testimony presented, I find that the parties have reached this decision freely and voluntarily. This is now an order of the court, and we're going to email you guys each a copy of this order, and you guys probably got to get moving on getting her enrolled. That's probably already something you got to get moving on in Lutheran North. And I'm going to plan on you guys being able to work out softball league after this year, as you both agree that she loves softball. So guys, make it happen. Okay, with that, guys, have a great day. Stay healthy and safe. And you guys should get a copy of this order by the end of the day via email. All right.
Thank you.
Thank you.
Thank you.
Thank you.
Hey, have a great day, everybody. Okay,
Thank
bye-bye.
you.
Thank you. You too. Bye.